We live in a world where it's become easy to throw people away. What we know is that currently 2.3 million citizens in the United States are incarcerated. The proliferation of prisons and mass incarceration are so common, these conditions are glamorized in movies and on television. Since when did we think orange was the new black? What we do know is that women are entering the prison system in record numbers, leaving behind minor children. According to sentencingproject.org, more than 5.7 million children under the age of 18 have experienced the incarceration of a parent. If and when these individuals are released, they soon find a world not ready to accept them back. The time spent and the records created follow them outside the prison walls. It can be likened to a punishment eternal. Those who are released soon learn the significant impact their criminal records have on their driving privileges, child custody, immigration, and employment. You see, the unemployment rates for those who have been incarcerated averages 27%, numbers higher than the 1929 Depression. Sadly, those rates are higher for African Americans. Their frustration with the re-entry process can create real obstacles to putting their shattered lives back together and is a contributing factor to a recidivism rate of 43% for released prisoners. Here are the legal options available to you when dealing with criminal and unflattering civil records that can follow you for a lifetime. You only have one life, so you need to equip yourself with the knowledge necessary to help rebuild it. Hi, I want to welcome everyone to another episode of Tabernacle Talks. And tonight we are so excited to have with us super lawyers. And believe me, when I say super lawyer, we're talking Jonathan Hollingsworth. And I want to give you just a little bit of Jonathan's background because he's going to be shy and not want me to just tell you all these great things about him. But I feel like it's important for us to understand that when we have this type of educated, articulate businessman, just community volunteer, then we have to be able to give you just all the background from him. I will tell you that he did his undergrad at Harvard. And he's a Harvard man, but he did go to University of Michigan Law School. He is a partner and member of Hollingsworth and Washington LLC, and that's in Centerville. He has many board appointments, adjunct faculty from Antioch University. He's also been adjunct faculty at University of Dayton Law School. Again, a super lawyer, Ohio State Bar Association president. John, I could probably go on for days and days and days about all of his accolades, but I promised him I would not. But I do want to welcome him to our program tonight. We are talking about pardons, commutations, and expungements, and I think that's an appropriate topic and a serious topic for many of our audience. So I think before we can really get into real discussion, I'd like to kind of engage John on giving us the definitions of those terms so that we understand going forward the difference and the similarity. So maybe if we start with pardon, John, we could start with that.
Well, thank you, Dr. Michelle, for embarrassing me. But we can. Well, the system of justice here in the United States has an established mechanism for allowing someone who has been convicted of a criminal offense relief from that offense. And that relief takes the form of what we think of as clemency. Clemency, however, has two main methods to it: a pardon and a commutation. A commutation is simply a partial relief granted to someone that might involve maybe a reduction in the criminal sentence or a reduction in a fine. A pardon is a complete relief. It grants a person and restores rights that the person may have had taken away as a result of the criminal conviction. But the important thing about a pardon is that it doesn't eliminate the conviction. It simply restores rights that the person had, as if the conviction hadn't occurred, but in fact the record of the conviction continues to exist. Executive clemency, which is a term that I'm sure we've all heard before, is used because it means it is the right given to the executive. In the case of the federal government, that's the president. In the case of a state government, that would be the governor.
Okay, thank you. That, I think, helps our audience understand the difference. And recently, we've heard and talked a lot about presidential pardons. Can you walk us through that process, the eligibility for a pardon? Do I need to ask for a pardon? Can the president just through common culture, think this is something that I can do for publicity's sake? What started that process? And if you could kind of walk us through that.
Well, first off, the pardon concept is in the United States Constitution. And to the extent the states were created over the course of the history of this country, each state has a pardon provision as well. At the state level, the pardon is executed by the governor. At the federal level, it's executed by the president. The president of the United States has the absolute right to determine whether or not to grant someone complete relief from a conviction. That right clearly exists in the Constitution. There are some procedures in place whereby the president could ask the Department of Justice through the office of the what's the name of that? I don't remember now. It's not coming back to me. But anyhow, there is the Office of the Probation Authority. The president could ask that person, that office, to conduct an investigation into a request by a person seeking relief from a conviction. But that is generally done in secrecy. The office would interview the prosecutor and the judge and check into the history of the individual seeking the relief and make a recommendation to the president. But the president doesn't have to follow that recommendation. The president can decide, independent of what that office may recommend, to grant or not grant the pardon. So in that regard, the pardon is absolute power granted to that executive office. However, it has limitations. The president cannot grant a pardon for acts of impeachment.
You heard it first on Tabernacle Talks. Thanks. I think I needed that. So when we talk about limitations, we know there's separation of powers. So you're telling us there's no limitation except in terms of an impeachment on presidential pardon power.
Sadly enough, that's true. Because when the Founding Fathers wrote the Constitution, they had every reason to believe that the pardon power would be used to achieve justice. And that's generally why it's granted to people. Now, later on, you and I may want to discuss some pardons that have been granted that might not suggest that something was done out of fairness, maybe politically motivated, maybe personally motivated. We'll let the audience decide. But the purpose behind the pardon is to be lenient and merciful. And that's why that authority was given to the executive branch of our government. In this case, it's bestowed solely upon the president.
So is there an application that you have to file? What's that process? Just through his presidential seal, can he say, I've read the record, I've pardoned you, and that's it? Or is there an application, interview? What happens in that regard?
There is an administrative process that the president may use, and it's through the Department of Justice. And I discussed it briefly before. However, the president need not use that process. All that need happen is someone would try to get before the president his or her request for the complete relief from the conviction. And once in front of the president, if the president decides that it's something that he, or in the future we might have a female president, she wants to do, then that person has the absolute authority to make that decision. The president is not constrained by any investigation that might be conducted by the Department of Justice in consultation with the FBI.
Okay, I've got a final question about pardons. Are there any, we talked about limitations of power. Are there any frameworks or state statutes that a president can't pardon?
Okay, so there's a difference between federal authority and state authority. So I've talked briefly about the federal authority in the executive branch there. At the state level, the governor is the one who has authority to grant clemency. In this case, it could be in the form of a pardon or some other relief, a commutation, for example. Ohio has such authority under its constitution, and our current governor, upon receiving an appropriate application and going through a statutorily demanded process, could grant relief. In Ohio, for example, a person would have to fill out an application submitted to the parole board. The parole board would decide whether or not to conduct a background check on that individual to determine what he or she has done since their conviction and their service of time. Might even interview a victim if there is a victim, and then makes a report to the governor. The governor then, upon getting that report, can decide whether or not to grant the clemency or the relief that's being requested. In Ohio, there are two ways in which the governor is handcuffed or cannot grant relief. The governor can't grant relief for, obviously, acts of impeachment, and cannot grant relief for treason. In Ohio, our Constitution requires that the issue of treason be addressed through the General Assembly, and that the General Assembly gets to decide whether or not a person who's committed treason might be granted a pardon or clemency.
Okay, then I think you've given us a perfect segue into the topic of commutations, because I think that's just as significant as a pardon. When we talk about a commutation, when would someone ask to have their sentence commuted? Is that something they ask for? Is that something their attorney asks for?
Well, assuming you have no attorney, you should and I believe will ask for it as soon as you think you're entitled to it. In other words, the purpose behind a commutation is to reduce the length of the sentence or to reduce the size of the fine. So you know at the time of conviction what your sentence is and what your fine is going to be by virtue of the court's order. Once you become aware of it, you then have to determine whether or not you are a person who would be eligible to be considered for that kind of relief. Generally speaking, you'd probably have to serve some of your time and maybe make the argument that the amount of time ascribed to you was inappropriate, it was punitive, in order to get the attention of the governor and the parole board so that they would review it, evaluate it, and determine whether or not there should be the kind of relief that you're looking for. Should your sentence be reduced in some way, and should your fine be reduced in some way?
I do have a question. I know that you kind of walked us through the difference between a pardon and clemency. And I was thinking about the Central Park Five. They didn't go through either of this. They actually went through a trial scenario again and were cleared. So they weren't, because a friend had asked me, were they pardoned? They weren't pardoned. They actually were exonerated. Can you kind of tell us the difference between being exonerated versus being pardoned?
Sure. Exoneration means that you've been proven innocent of the charges against you. A pardon is granted only after a conviction. So there'd have to be a trial, or you'd have to, and through that trial, there's a finding by a court that deems you guilty of the crime. And only after that would you then be in a position where a pardon might apply? Because remember, a pardon is designed to give you relief from the conviction, whereas exoneration means you've been proven innocent of the charges asserted against you.
Thank you for giving us that clarification. Okay, I want to move on to expungements because I think, at least for our audience, that is probably something that they are more familiar with, particularly when many individuals may have marks or scars on their records and they're applying for employment and that question comes up. When should a person seek expungement of a record?
Okay, so expungement is different from a pardon and it's different from a commutation because an expungement is granted by the judiciary. A pardon or commutation is granted by the executive branch of the government, the president in the case of federal crimes and the governor in the case of state crimes. So there's a big difference. An expungement is a process where a person who's been convicted of a crime may want to seek to have that record removed entirely and no longer attributed to him or her so that it wouldn't adversely affect his or her future. In the case of the expungement, if you get it and it removes it's an action by the judicial branch and it removes the crime from your record, then it's as if it didn't exist. It's destroyed, it's gone. Whereas what we normally confuse that with is sealing of a criminal record. Sealing of a criminal record doesn't mean the conviction is gone. It just means it's been sealed, it's been put away somewhere, and may be used again or recovered for that purpose. Whereas expungement absolutely gets rid of the conviction.
So let's talk about what type of records are appropriate to seek or go through that expungement process. Can you walk us through what type of record would qualify for that?
Yeah, that's tough. The statute lays out in some detail what types of criminal conduct that one might be eligible for an expungement. For example, in the federal system, there is no expungement statute. So that concept generally doesn't get used often, although it has been applied in the case of nominal criminal possession charges. In the state case, you can't get an expungement for adult criminal conduct. For the most part, you just can't get that. You can get an expungement generally with respect to juvenile convictions, but the courts in juvenile cases will only expunge the record if it's sealed. But at the adult level, adult conduct, generally, you just can't get an expungement. You're really looking more at the idea of trying to seal the record for adult criminal conduct.
Is there a cost associated with expungement?
Well, there always is. We have to make a living as lawyers. And so one of the ways a person who's been convicted of a crime who's looking to have the record expunged can help him or herself is to pull together the file, get the records that make up the conviction, and make all that stuff available to the lawyer so that the lawyer can help walk you through the preparation of the form that gets submitted to the court for review in determining whether or not to grant your request for expungement. It can cost as little as a few $100s, and depending on how complicated the matter is, could cost a few $1,000s.
Let's talk about criminal records and how they can influence a variety of aspects of your life, from your driving privileges, employment. What advice and guidance do you give individuals when they have their criminal background and they're looking for a job?
Well, first thing I would do is to say to you that if you have a juvenile record, for example, you want to have that record expunged or sealed as soon as you can. whenever you become eligible for that to happen. In the case of juvenile records, for example, if it's sealed, most of them are automatically expunged after 5 years. There are some juvenile criminal conduct that doesn't lead to the sealing of your record, such as murder, of course, and rape. And so those records remain there for your lifetime. You can't expunge those. But as soon as you are eligible for an expungement, you should seek to expunge the record so that it doesn't adversely affect any opportunities you may wish to pursue going forward. And it could affect your employment. Clearly, the opportunity to get a job, if expunged, it doesn't exist. Which means no one will see it, therefore it should never be a part of any question by an employer. It shouldn't become an issue with you seeking a job for the most part. However, it may be relevant if you seek a job in law enforcement or you seek a job in an area where the courts determine that it's necessary for that information to be made available in order for a fair assessment to be made of you as a prospective employee.
Now, this is probably a loaded question because I've worked in HR many, many years. Many applications will ask a question, and I think they still ask these questions. Have you ever been convicted of a crime? Yet, an individual maybe in good faith has expunged a record, and you just explained to us that that record has been destroyed or it does not exist. So when a person comes across that question on their application, have you ever been convicted of a crime, but you know you've had that record expunged, how are they supposed to answer that question?
That is a loaded question. It's more of a morality question from the standpoint of how you answer the question, truthfully or not. But the concept of expungement is intended to give that person another opportunity. Otherwise, we wouldn't have a system of justice that would allow us to have the record closed in such a way as to be destroyed as if it never existed. So most people would probably not say, I was convicted and I had the record expunged when I was a juvenile. They would probably say, no, I've never been convicted. No one's going to be able to find that record once it's expunged, therefore the answer technically could never be determined to have been false. That's why I say it's a question of morality. You know. The question is, for second chances, though, the law has given you that, and that's probably the answer to the question.
Okay, so maybe this is a secondary question of that, arrests. And I've always been told that people don't have to disclose arrests when they're going through an employment process on the application. Is that still current advice to an applicant?
To not disclose whether or not they've been arrested? An arrest is not a conviction, and it seems to me that that's not going to present a problem with a prospective employer. It is the conviction, that the charging of a crime, for example, and the conviction, because you can be arrested for jaywalking, but if you're not ultimately dismissed, the charges against you ultimately dismissed, is that something that you should report to a prospective employer? Again, there's a morality component to what constitutes the truth, but quite frankly, it's going to be up to that person to decide whether or not he or she wants to acknowledge being arrested, even if the charges were dropped.
Okay, so go over for our audience again, just so they're clear, and I want to make sure that I'm clear on it too. There are differences between an expunged record and a sealed record, and can you review that again, just so we're clear?
An expunged record is a record that is destroyed. It no longer exists. It's as if it never existed. A sealed record is simply a record that has been put away, locked up, such that it is only available in very limited circumstances to public officials, for example. it can always be unsealed. It isn't destroyed, it doesn't go away, and you don't get to treat it as if it never existed.
Wonderful. So if you could give our audience any guidance in terms of if they're looking at maybe they've had some problems or difficulty getting insurance or driving privileges or employment, what process should they go through to actually find out what's in their background? Is there a free way they can actually look up their criminal records to see what's listed with the courts? How should they start?
Yeah, I don't know what's available online despite all the technology we have today. I doubt that you can find all of your criminal record, if there is such a thing, by simply looking online. I'd contact the local sheriff's office or the Ohio Bureau of Criminal Investigations because they run background checks for employers all the time. And they would walk you through the process for doing a background check to determine whether or not you have a criminal history that you may or may not wish to consider having sealed. But that's probably the best way to figure out whether or not there's something out there if you don't know or don't recall.
Okay. I always give you, the guest, the last word. So what would you like to leave our audience with on this topic?
Well, I was going to tell you a number of stories about pardons that have occurred over the course of the 200 plus years of this nation.
Well, I'd like to hear them.
Just to give you some idea, because most people are sitting around thinking about, in today's political environment, they're thinking about self-pardons. Well, self-pardons, I've never seen one. I doubt that there's ever going to be one, and there's a good reason for it. Remember I told you earlier that a pardon basically clears you of a conviction. So before you can get a pardon, you have to have a conviction. If you're not convicted of anything, you can't have a pardon. So some people who talked about self-pardoning the president, doing that on the way out of office, well, having never been convicted of a crime, you can't issue a pardon. And of course, out of office, you can't issue a pardon either. So the concept of self-pardoning, I think, is interesting. In the history of this country, we've had two presidents who did not grant pardons. Unfortunately, these two presidents didn't live long enough to grant pardons. They were only in office for a couple of months, took ill, and passed away. So that tells you something. 46 presidents, the current one just barely in office, I don't know of any pardons that have been issued by him, but of the previous 45, 43 granted pardons, which means the Founding Fathers knew what they wanted to see done here, and that for the most part, the people who have held the highest office in this country have utilized that power for the purpose in which it was intended, and that was to do good. And that's a good thing. We need a mechanism by which we can grant relief where the justice system somehow didn't do the right thing by a particular person.
Wow. I just want to thank you, Jonathan. Like I told the audience, super interview with a super lawyer. I want to thank you for joining us this evening on Tabernacle Talks, and we will see you next week, Tuesday, 6:30. I'll leave you with some closing thoughts, though.